In 1955, a newspaper in Philadelphia ran a help-wanted advertisement for an accountant. The ad specified the salary, the qualifications, the industry experience required. And at the bottom, in plain text, it specified the age range the employer was looking for: applicants between 25 and 40 years old. Nobody thought this was unusual. Nobody complained. Nobody sued. The Philadelphia employer was doing what employers across the country did routinely, using age as a hiring criterion the same way they used education or experience, openly, in print, without any expectation that this was legally or socially problematic. In 1958, a survey of help-wanted advertisements in major American newspapers found that roughly half of all private sector job listings included age specifications, most of them excluding applicants over 40 or 45. These were not subtle preferences communicated through coded language. They were explicit requirements printed in the newspaper, reflecting an employment market in which age discrimination was not just tolerated, but normalized. The worker who turned 45 in 1955 and lost his job, for any reason, was in a genuinely precarious situation. His age made him significantly less employable in the open market. His Social Security was a decade away. His savings, if he had any, were the only thing standing between him and a financial crisis that could persist for years. And the law offered him nothing, because the law did not recognize age as a characteristic deserving of protection. The Age Discrimination in Employment Act was signed by President Lyndon Johnson on December 15, 1967. It prohibited employers with 25 or more employees from discriminating against workers between the ages of 40 and 65 in hiring, firing, compensation, or terms and conditions of employment. It was the first federal law to protect workers from employment discrimination based on age. It passed with remarkably little controversy compared to the Civil Rights Act of 1964, which had provoked months of Senate filibuster and one of the most intense political battles of the decade. The age discrimination law moved through Congress with relatively modest opposition, was signed without ceremony, and received limited press coverage. The discrimination it prohibited was, if anything, more pervasive than racial discrimination in the employment market, affecting a larger fraction of the workforce and operating with greater visibility. But it generated a fraction of the political heat. This is the story of what age discrimination in American employment actually looked like, how pervasive it was, who it affected, what it cost those workers and their families, and why it took 191 years from the founding of the Republic to establish that firing someone because they were too old was a form of illegal discrimination. It is also the story of why, 58 years after the law's passage, age discrimination in the workplace remains more common, more difficult to prove, and more economically damaging than almost any other form of employment discrimination that federal law prohibits. To understand age discrimination in the pre-1967 American labor market, you need to understand the specific mechanisms through which it operated, because it was not a single practice, but a set of interlocking practices that worked together to systematically exclude older workers from employment. The most visible mechanism was the explicit age specification in job advertisements. The help-wanted sections of American newspapers in the 1940s and 1950s were full of listings that specified age ranges, age maximums, or preferences for youth in terms that left no ambiguity about what the employer was looking for. A factory wanting assembly line workers might specify men between 20 and 35. An insurance company wanting sales agents might specify men between 25 and 40. A department store wanting floor staff might specify women between 18 and 30. The age specification was treated as a legitimate business criterion equivalent to the educational requirements or experience specifications that accompanied it. The second mechanism was the mandatory retirement policy. Many large employers in the mid-20th century had mandatory retirement ages written into their employment policies, typically between 60 and 65. These policies required workers to leave their jobs at a specified age regardless of their health, their performance, their productivity, or their financial situation. A worker who reached the mandatory retirement age on a Tuesday was required to stop working on Wednesday, whatever their circumstances. Mandatory retirement policies had a surface logic that their proponents articulated with confidence. They opened up positions for younger workers, allowed for orderly succession planning, and prevented the awkward situation of managing out an older worker who was no longer performing adequately. The logic was not without foundation. Managing the performance of older workers who had declined in capability was genuinely difficult in an era before human resources practices had developed the tools for doing it professionally. But the mandatory retirement policy also removed workers who were performing well, workers who had knowledge and experience that was valuable to their employers, workers who were not ready to retire financially and who faced years of reduced income as a result of being forced out. The policy was indiscriminate by design. It applied the same fate to the declining worker and the still productive worker. because discrimination on the basis of age was cheaper and simpler than discrimination on the basis of actual performance. The third mechanism was the informal preference for youth in hiring decisions that operated without any explicit age specification but that produced the same result. An employer who received applications from a 35-year-old and a 55-year-old with equivalent qualifications frequently chose the younger applicant, for reasons that were rarely articulated explicitly but that reflected a set of assumptions about younger workers' trainability, their longer expected tenure with the company, their lower healthcare costs, and their greater adaptability to changing conditions. These assumptions were not uniformly wrong. Younger workers did, on average, have longer expected tenure than older workers, though the difference was less significant in stable industries than employers assumed. Healthcare costs were lower for younger workers, though this reflected the structure of employer-provided health insurance rather than any inherent difference in productivity. The assumption about trainability and adaptability was the most factually questionable, with research consistently showing that older workers were as capable of learning new skills as younger workers when given the same training opportunities. But the assumptions persisted because they were self-reinforcing. Employers who believed older workers were less adaptable hired fewer of them, which meant they had fewer examples of adaptable older workers to challenge the belief. The discrimination was invisible to those who practiced it because it felt like rational decision-making rather than bias, and because there was no legal framework that required them to examine their assumptions. The economic consequences for displaced older workers were severe and well documented by the time Congress began seriously considering age discrimination legislation in the mid-1960s. A Labor Department study conducted in 1965 found that workers over 45 who lost their jobs remained unemployed significantly longer than younger workers who lost comparable jobs, that they were more likely to accept lower wage employment when they did find work, and that they were more likely to leave the labor force entirely and draw down savings or take early Social Security benefits that permanently reduced their monthly income. The study found that the unemployment duration for workers over 45 was on average twice that of workers between 25 and 34 who lost equivalent jobs. This was not a product of any difference in the intrinsic job-seeking ability of the two groups. It was a product of the discrimination that older workers encountered in the hiring market, which reduced the pool of employers willing to consider them and extended the search time required to find one of the employers who would. The permanent income consequences of this displacement were significant. A worker forced into early retirement or forced to accept a lower wage job at 55 faced not just immediate income loss, but a permanent reduction in the Social Security benefit they would eventually receive, because Social Security benefits were calculated on lifetime earnings. Years of lower earnings at the end of a career dragged down the benefit calculation in ways that persisted for the rest of the worker's life. The discrimination at 55 was still affecting income at 75. The political movement to address age discrimination in employment developed differently from the movements that produced the Civil Rights Act of 1964 and the Equal Pay Act of 1963. Those laws emerged from mass political movements, from organized constituencies that had been fighting for civil rights and equal pay for years or decades, from dramatic public confrontations that made the injustice visible to people who had not previously seen it. The age discrimination law emerged from a more technocratic process, a Labor Department report, a presidential directive, a relatively quiet legislative process. The 1965 Older Americans Act, which established the federal infrastructure for services to the elderly, directed the Secretary of Labor to study age discrimination in employment and report to Congress. The resulting report, delivered in 1965, documented the scope of age discrimination with the kind of quantitative precision that made it difficult to dismiss. The report found that age was a factor in the rejection of approximately half of all job applications from workers over 45, that explicit age limits in job advertisements were widespread, and that the economic consequences for displaced older workers were severe. The report also made a recommendation that became the basis for the 1967 legislation. Federal prohibitions on age discrimination in employment, modeled on the employment discrimination provisions of the Civil Rights Act of 1964, but limited to workers over 40. The choice to model the age discrimination law on the Civil Rights Act was itself a significant decision because it determined the enforcement framework, the remedies available to workers who experienced discrimination, and the standard of proof required to establish a violation. The Civil Rights Act model required workers to prove that their protected characteristic, race, sex, or in this case age, was a motivating factor in an adverse employment decision. This standard, while lower than requiring proof that age was the only factor, still imposed a significant burden on workers who experienced discrimination because the employer's actual reasons for an employment decision were frequently known only to the employer. The employer's exclusive knowledge of its own decision-making process has been the central practical challenge of age discrimination enforcement since the law's passage. An employer who declines to hire a 55-year-old applicant in favor of a 35-year-old applicant rarely explains that the applicant's age was the reason. The employer says the other candidate was more qualified, was a better cultural fit, had more relevant experience, was more enthusiastic about the role. These explanations are difficult to disprove without access to the employer's internal deliberations, which workers rarely have. The law did provide mechanisms for gathering this evidence. Discovery in litigation could reveal internal communications, performance evaluations, demographic data about hiring and firing patterns, and other information that could support an inference of discriminatory motivation. Statistical evidence showing that an employer systematically hired or retained younger workers at the expense of older workers with equivalent qualifications could support a discrimination claim. But litigation is expensive, time-consuming, and uncertain. Most workers who experience age discrimination do not sue, either because they do not recognize what happened to them as legally actionable, because they lack the resources to pursue litigation, or because they calculate that the cost and disruption of litigation is not worth the uncertain prospect of recovery. The workers who do sue face a legal process that can take years and that requires them to prove not just that they were treated worse than a younger worker, but that age was the reason, a standard that employers can contest with facially neutral explanations that are difficult to disprove. The legal framework for age discrimination claims became significantly more restrictive in 2009, when the Supreme Court decided Gross versus FBL Financial Services. The decision held that workers bringing age discrimination claims under the ADEA had to prove that age was the but-for cause of the adverse employment action, meaning that the worker had to show that age was the decisive factor, not merely a contributing factor. This standard is higher than the standard that applies to race and sex discrimination claims under the Civil Rights Act, where workers need only show that the protected characteristic was a motivating factor. The Gross decision made age discrimination claims significantly harder to win than race or sex discrimination claims, even though the basic statutory prohibition is similar. The practical effect was to reduce the legal accountability of employers for age discrimination at exactly the time when the aging of the baby boom generation was making the pool of potentially affected workers larger than it had ever been. The aging of the American workforce was already the most significant demographic trend of the early 21st century before the Gross decision made discrimination claims harder to win. By 2025, workers over 55 represent a larger share of the American workforce than at any previous point in the country's history, and workers over 65 are the fastest-growing segment of the labor force. The combination of longer lifespans, inadequate retirement savings, and the financial necessity of continued employment has kept millions of older workers in the labor market well past the ages at which previous generations would have retired. These workers are encountering the same discriminatory practices that the 1967 law was designed to address, now operating through mechanisms that are more sophisticated but no less effective. The explicit age specifications in newspaper advertisements have been replaced by preferences for recent graduates, for candidates who are digitally native, for people who fit the company culture, phrases that serve as proxies for youth without stating age directly. The mandatory retirement policies that the 1978 ADEA amendment eliminated in most private sector employment have been replaced by performance management systems and restructuring processes that disproportionately remove older workers while maintaining plausible deniability about the role of age. The tech industry has been particularly scrutinized for age discrimination, with multiple high-profile cases and investigations finding patterns of discriminatory treatment against workers over 40 in hiring, promotion, and layoffs. The industry's cultural preference for youth, sometimes stated explicitly in terms of the need for fresh thinking or digital nativity, and sometimes expressed through the hiring practices and demographic profiles that result, has produced workforces that skew dramatically young compared to the broader economy. The layoffs that have periodically swept through the tech industry have produced significant litigation, with workers alleging that age was a factor in layoff decisions. The statistical evidence in some of these cases has been striking, analyses showing that workers over 40 were laid off at significantly higher rates than younger workers in the same job categories, controlling for performance ratings and seniority. These statistical patterns are consistent with age discrimination but are not conclusive proof of it, because employers can and do offer alternative explanations that courts must evaluate case by case. The Amazon warehouse worker who is pushed out through a performance management system that tracks productivity by the second, the IBM software engineer who is laid off in a restructuring that disproportionately affects workers over 50, the hotel housekeeper who is not called back after a pandemic layoff because the hotel prefers to hire younger workers. These are the contemporary faces of the age discrimination that the 1967 law was designed to address. The law has not succeeded in eliminating the discrimination. It has made it somewhat more costly for employers, somewhat more risky legally, and somewhat more difficult to practice openly. But the discrimination persists, in forms sophisticated enough to evade easy legal challenge, affecting millions of workers whose age has made them economically vulnerable in ways that the law has not fully addressed. The 1978 amendment to the ADEA, which raised the upper age limit for protection from 65 to 70 and later to no upper limit at all, eliminated mandatory retirement in most private sector employment, and extended the law's protections to workers of any age over 40. This was a significant expansion of the law's coverage, addressing the mandatory retirement practices that had forced workers out of employment regardless of their performance or their financial need. But eliminating mandatory retirement in law did not eliminate the economic and social pressures that produce retirement, voluntary or otherwise, at ages that workers might not choose in a more equitable labor market. A worker who has been passed over for promotion for 5 years, who has been assigned to marginal projects while younger colleagues receive the high-profile work, who has watched her salary remain flat while younger colleagues receive increases, is technically not being forced to retire. She is experiencing a set of conditions that make continued employment increasingly unrewarding and that make the decision to leave feel like a personal choice rather than the product of discriminatory treatment. This is the most pernicious form of contemporary age discrimination. The management of older workers in ways that are individually defensible but that collectively constitute systematic disadvantage, that push workers toward exits that feel voluntary but are substantially coerced. The law struggles to address this form of discrimination because it lacks a single discriminatory act to point to. The discrimination is distributed across many small decisions, each of which can be explained by reference to the specific facts of the situation, and that together produce an outcome that looks like discrimination in the aggregate, but that is difficult to challenge in any individual case. The experience of workers who are displaced in their 50s and who struggle to find equivalent employment illustrates the ongoing practical consequences of age discrimination, whatever its legal status. A manager laid off at 54 who takes 3 years to find equivalent employment, accepting significantly lower compensation in the interim, has experienced a permanent reduction in lifetime earnings and retirement savings that will affect her financial security for the rest of her life. Whether the initial displacement was legally discriminatory, whether she could have proven it in court, is somewhat beside the point. The economic harm is real regardless of whether it is legally redressable. The policy responses to this reality have been limited. The ADEA's remedies, which include back pay, reinstatement, and in cases of willful violation additional damages, are calibrated to compensate individual workers for specific discriminatory acts, rather than to address the systemic disadvantage that older workers face in the labor market. The law is fundamentally a complaint-driven enforcement mechanism, requiring individual workers to identify discrimination, document it, file charges, and pursue litigation or settlement, a process that is accessible only to workers with the resources and information to navigate it. More proactive approaches, including the kind of affirmative obligation to consider older workers' representation in the workforce that some researchers have proposed, have not been enacted. The political support for such measures is limited, partly because age discrimination lacks the organized political constituency that racial and sex discrimination have, and partly because the business community has consistently opposed any expansion of the ADEA's requirements beyond the prohibition on specific discriminatory acts. Understanding this history, from the help-wanted ads of the 1950s that excluded anyone over 40, to the 1967 law that prohibited the explicit exclusion, to the sophisticated contemporary practices that produce similar outcomes through more subtle means, is essential for understanding both what the law achieved and what it failed to achieve. The achievement is real. The explicit age specifications that filled newspaper help wanted sections in the 1950s are gone, replaced by less explicit but still operative preferences. The mandatory retirement policies that forced productive workers out at 60 are largely illegal and largely gone. Workers who are discriminated against on the basis of age have legal recourse, imperfect and difficult to exercise, but real. The failure is equally real. Age discrimination persists throughout the American labor market, affecting millions of workers whose age has made them economically vulnerable and whose legal remedies are insufficient to the scale of the discrimination they face. The worker who is displaced at 55 and faces years of reduced employment and reduced income before reaching Social Security eligibility faces a situation that the 1967 law was designed to prevent and has not prevented. The gap between the law's promise and its delivery is the persistent challenge of employment discrimination law in all its forms. The Civil Rights Act of 1964 did not eliminate racial discrimination in employment. The Equal Pay Act of 1963 did not eliminate the gender pay gap. The Age Discrimination in Employment Act of 1967 did not eliminate age discrimination in employment. Each of these laws made the discrimination more costly, more legally risky, and more difficult to practice openly. None of them eliminated the underlying practices that produced discriminatory outcomes. What would eliminate those practices is a combination of stronger legal standards, more robust enforcement, and the cultural change that comes from sufficient accountability. The legal standards for age discrimination claims are currently weaker than those for race and sex discrimination claims, a product of the Gross decision that Congress has not reversed. The enforcement resources devoted to age discrimination are limited relative to the scale of the problem, and the cultural change that would make age discrimination as socially unacceptable as other forms of discrimination has not occurred, partly because age discrimination is so normalized that many people who practice it do not recognize it as discrimination. The Help Wanted ad in 1955 that said no one over 40 need apply was not placed by someone who thought of himself as a discriminator. He thought he was being practical. The hiring manager in 2025 who passes over the 55-year-old applicant in favor of the 32-year-old does not think of herself as a discriminator either. She thinks she is making a judgment about fit, about energy, about cultural alignment. The law says both of them are wrong, and it has been saying so since 1967. The gap between what the law says and what happens in practice is still large, still measurable, and still imposing real costs on real workers whose age has been used against them. From the newspaper Help Wanted ads of 1955 to the algorithmic hiring systems of 2025. From the mandatory retirement policies that ended careers at 60 to the performance management systems that produce the same outcome through more sophisticated means. From the Labor Department report of 1965 to the Supreme Court decision of 2009 that made age discrimination harder to prove. The history is longer than most people know. The problem is larger than the law has been able to address. And the workers who are living it right now, updating their resumes at 55, wondering whether their age is the reason they are not getting callbacks, deserve a legal system that takes their situation as seriously as the law's text suggests it does. That is the history of age discrimination law in America, and it is not finished. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. To understand the full scope of what age discrimination cost American workers in the pre-1967 era and what it continues to cost them today, you need to follow specific workers through the experience rather than staying at the level of policy and statistics. Because the statistics describe the pattern, but the pattern is made of individual lives, and the individual lives are where the actual cost becomes visible. Consider the experience of a manufacturing worker in Cleveland in 1960. He is 52 years old. He has worked in the same factory for 20 years, building expertise in a specific type of precision machining that took years to develop, and that makes him one of the most valuable workers on the floor. The factory is bought by a larger company. The new company conducts a workforce review and decides to consolidate operations. The worker is laid off. He begins looking for work immediately. His skills are genuine and verifiable. His track record is strong, but the factories he applies to are looking for younger workers who can be trained from scratch into the specific processes those factories use, and who will cost less in salary and benefits. The worker's experience, which should make him more attractive to employers, is being used against him. He commands a salary consistent with his 20 years of experience, and employers prefer to pay less for someone they can shape to their specific needs. He is unemployed for 18 months. He finally finds work in a smaller shop at 2/3 of his previous salary. His Social Security benefit, when he eventually collects it at 65, is permanently reduced because his final years of earnings were significantly lower than his peak earnings. He works until 68 because the reduced Social Security benefit is not enough to retire on comfortably. He dies at 74, having spent his final working years at a salary that never recovered the loss sustained at 52. This trajectory, compressed into a paragraph, was the trajectory of millions of American workers in the decades before and after the age discrimination law. The law changed the legal status of what happened to the Cleveland machinist. It did not change the economic reality sufficiently to prevent similar trajectories from occurring in subsequent decades. The research on the economic effects of job displacement at older ages is consistent and sobering. Workers displaced after age 50 experience earnings losses that persist for the rest of their working lives. They are significantly more likely than younger, displaced workers to leave the labor force entirely rather than finding new employment. They draw down retirement savings to cover the gap between unemployment benefits and living expenses. permanently reducing the assets available to fund retirement. And they take Social Security earlier than they would have planned, permanently reducing their monthly benefit. A study by the Urban Institute found that workers displaced after age 50 suffer average earnings losses of about 18% that never fully recover. The cumulative lifetime earnings loss from a displacement at 52, compared to continued employment at the same wage, can easily exceed several $100,000. The Social Security benefit reduction that results from years of lower earnings adds tens of thousands more in reduced lifetime income. The total economic impact of a single age discriminatory job displacement, measured over the remaining lifetime of the worker, is larger than almost any other form of employment discrimination. This magnitude of harm is not reflected in the legal remedies available under the ADEA. The primary remedy for a successful age discrimination claim is back pay, the wages the worker would have earned but for the discrimination. Back pay compensates for the immediate income loss but does not compensate for the permanent reduction in earnings trajectory, for the reduced Social Security benefit, for the retirement savings depleted during the unemployment period, or for the years of lower wage employment that followed. The remedy fits the legal framework of a discrete discriminatory act but does not match the economic reality of a harm that propagates forward through decades of the worker's life. The inadequacy of the legal remedy is one reason that the ADEA has not succeeded in deterring age discrimination more effectively. An employer who calculates the cost-benefit analysis of discriminating against older workers faces a risk of legal liability that is capped at back pay plus, in cases of willful violation, an equal additional amount in liquidated damages. Against this risk, the employer weighs the cost savings from hiring younger workers at lower salaries, the reduced healthcare costs, and the cultural benefits of a younger workforce that many employers in certain industries genuinely believe they receive. In many cases, the calculation favors discrimination because the probability of being caught and successfully sued is low, and the damages, even if the suit succeeds, are limited. This cost-benefit calculation is more favorable to discrimination in the tech industry than in many others, because the salary differentials between senior workers and their younger replacements can be very large. The healthcare cost differentials are significant, and the cultural preference for youth is particularly strong. The pattern of age discrimination in tech is therefore both economically rational from the employer's perspective and particularly damaging from the worker's perspective, because tech salaries are high enough that displacement from a senior tech position to a lower-paying alternative produces a very large earnings loss. The investigations and litigation involving major tech companies on age discrimination have produced some of the most detailed public evidence of how contemporary age discrimination operates in a sophisticated corporate environment. The evidence in these cases typically shows a combination of explicit statements by managers about wanting younger workers or wanting to change the culture, statistical patterns in hiring and layoff decisions that disproportionately affect workers over 40, and performance management processes that appear to be used to build cases for dismissal against specific workers rather than to genuinely address performance issues. The explicit statements are the most useful evidence in litigation because they directly link the adverse employment action to the protected characteristic. But they are increasingly rare, because managers in large corporations have received enough legal training to know that saying we need some fresh blood is legally problematic even if the sentiment behind it remains operative. The statements have been replaced by coded language that serves the same function. We need people who are nimble, we're looking for someone who can grow with the company, we need a culture fit with our team, all of which can mean we prefer younger workers without saying so in legally actionable terms. The statistical evidence is more difficult to contest, but also more difficult to translate into legal liability, because statistical patterns at the organizational level do not automatically prove that any individual decision was discriminatory. An employer can acknowledge that its workforce has gotten younger on average while arguing that each individual hiring or layoff decision was made on the merits. The gap between the aggregate pattern and the individual decision is the space in which age discrimination survives a legal challenge. The legislative history of the ADEA contains an extended debate about whether the law should include a disparate impact theory of liability, under which employers could be held liable for employment practices that produce discriminatory outcomes even without proof of discriminatory intent. The Civil Rights Act of 1964 was interpreted by the Supreme Court in Griggs v. Duke Power in 1971 to include disparate impact liability for race discrimination, meaning that an employer practice that produced racially discriminatory outcomes was illegal even if the employer had not intended to discriminate. The question of whether disparate impact liability applied to age discrimination was contested for decades. The Supreme Court addressed it in Smith v. City of Jackson in 2005, ruling that disparate impact claims were available under the ADEA, but that the standard for proving them was higher than the standard for race discrimination. Employers facing age disparate impact claims could defend their practices by showing that they were based on reasonable factors other than age, a defense that is not available in the same form for race disparate impact claims. The higher standard for both disparate impact claims and intentional discrimination claims under the ADEA reflects a judgment embedded in the law's interpretation that age discrimination is somehow less serious than race or sex discrimination, or that the business justifications for age-related employment decisions are more legitimate than the business justifications for race or sex-based decisions. Whether this reflects a defensible distinction between different forms of discrimination or simply reflects the political and legal history of how different civil rights laws were developed and interpreted is a question that reasonable people answer differently. What is not in question is the practical consequence. Workers who experience age discrimination have less legal protection than workers who experience race or sex discrimination, and the gap between their legal rights and the legal rights of other protected groups has widened since the Gross decision of 2009. Congress has had opportunities to reverse the Gross decision by amending the ADEA to apply the motivating factor standard that applies to race and sex discrimination, rather than the but-for standard that the Supreme Court read into the ADEA. The Protecting Older Workers Against Discrimination Act, which would make this change, has been introduced in multiple Congresses without passing. The business lobby has opposed it consistently, arguing that applying the motivating factor standard would make it too easy for workers to sue and would create excessive litigation risk for employers. Whether the act passes in future Congresses will depend on the same political dynamics that have determined the evolution of the ADEA since its passage in 1967, the relative political power of older workers who benefit from stronger protections and employers who benefit from weaker ones. The older workers are more numerous than ever, as the baby boom generation ages through the peak years of workforce participation and into the years when age discrimination risk is highest. Whether their political power translates into legislative protection for their employment rights is a question whose answer depends on how organized they are and how clearly they understand what is at stake. The Cleveland machinist of 1960 did not know that what happened to him was discrimination. He knew it was unfair. He knew that his experience was worth something and that employers were not recognizing it. But he did not have the legal framework to identify what was happening as discrimination, because the legal framework did not exist yet. The 55-year-old engineer in Silicon Valley who was laid off in a tech company restructuring in 2025 has the legal framework. She knows that what happened to her might be age discrimination. She may not know how difficult it is to prove, how limited the remedies are, and how small the probability of a successful legal challenge is. She has the law. She does not necessarily have the protection that the law promises. The gap between the law's promise and the protection it delivers is the story of the Age Discrimination in Employment Act, from its passage in 1967 to its enforcement in 2025. That gap is the distance between what a just employment system would look like and what the American employment system actually is for workers whose age has become a liability. Subscribe if this kind of history is what you are here for. There is more ahead. There is one more dimension of this history that connects the past to the present in ways that are becoming more urgent as the American workforce ages. That dimension is the intersection of age discrimination with the rapid technological change that is transforming the American economy, and specifically with the displacement of workers by automation and artificial intelligence. The history of age discrimination in employment has always been partly a history of technological change. The Cleveland machinist of 1960 was displaced partly by a corporate restructuring and partly by changes in manufacturing technology that made his specific skills less central to the production process. The textile workers who lost their jobs as looms became more automated faced age discrimination in the search for new employment in industries where their skills did not transfer. Technological change has always served as a mechanism through which older workers, whose skills were developed for a previous technological era, found themselves disadvantaged in a labor market oriented toward new technologies. What is different about the current wave of technological change, driven by artificial intelligence and automation, is its speed, its scope, and its specific impact on cognitive work that older workers are particularly concentrated in. Previous waves of automation primarily displaced workers in routine physical tasks: the factory assembly line, the data entry position, the driving route. The current wave is displacing workers in routine cognitive tasks, including many of the white-collar occupations that older workers with decades of experience are disproportionately concentrated in. A legal profession that is automating document review and contract analysis is a legal profession that needs fewer associates to perform those tasks, and the associates it does need are those who can work with the new tools, which typically means more recently trained lawyers who learned those tools in school. An accounting firm that is automating tax preparation and financial analysis is an accounting firm that needs fewer accountants for those tasks, and the accountants it does need are those who can supervise and interpret the automated output, a task that premium employers increasingly believe is better performed by younger workers with specific technical training. This dynamic is producing a form of age discrimination that is harder to challenge legally than the more direct forms, because it is mediated by genuine technological change that employers can point to as the reason for their employment decisions. An employer who replaces a 55-year-old accountant with a software system and a 28-year-old data analyst to supervise it has not made a decision that is obviously discriminatory in the same way as an employer who declines to hire a 55-year-old because of her age. The employer has made a genuine business decision about technology adoption that happens to have age-disparate effects. Whether the age-disparate effects of technology-driven restructuring constitute age discrimination under the ADEA is a question that the courts are beginning to address with increasing frequency, and that has not yet produced a clear answer. The legal framework for disparate impact claims, which is the theory most naturally applicable to practices that have discriminatory effects without necessarily having discriminatory intent, is particularly weak for age discrimination claims under the Gross Standard. An employer defending a restructuring that disproportionately affected workers over 50 can point to the technological rationale for the restructuring as a reasonable factor other than age that defeats the disparate impact claim. This is not a theoretical problem. It is a practical one that is affecting tens of thousands of workers in the industries that are undergoing the most rapid technological transformation. The IBM case, which involved allegations that the company systematically targeted older workers for layoffs over a period of years while replacing them with younger workers, involved restructuring decisions that IBM defended as responses to technological change and competitive pressure. The litigation, which produced detailed evidence about the company's internal deliberations, suggested that age was a significant factor in the targeting of specific workers for displacement, but the legal outcome was limited by the high standard of proof required under the gross but-for causation standard. The broader question of what policy response is appropriate to the age-disparate effects of technological change goes beyond the ADEA's individual complaint framework. If automation and artificial intelligence are producing systematic displacement of older workers at a scale that the legal system's complaint-driven enforcement mechanism cannot address, then the policy response needs to include mechanisms that operate at a systemic rather than individual level. Proposals in this space include requirements that employers document and justify the age demographics of restructuring decisions, tax incentives for retraining and reemploying older workers, expanded access to retraining programs specifically designed for older workers who need to develop skills for a changed labor market, and stronger enforcement resources for the EEOC's age discrimination investigations. None of these proposals has achieved significant legislative traction, partly because the political coalition that would need to support them has not been assembled, and partly because the business community opposes most of them as adding compliance costs and litigation risk that would reduce economic efficiency. The political difficulty of building the coalition for stronger age discrimination protection reflects something important about how age discrimination differs from other forms of discrimination as a political issue. Race discrimination affects a specific demographic group that has a clear group identity, a history of organized political advocacy, and strong institutional networks for political mobilization. Sex discrimination affects a majority of the population that has built significant political organizations around gender equity. Age discrimination affects a group, older workers, that is politically heterogeneous, that does not have strong institutional networks specifically organized around age discrimination in employment, and whose members frequently do not identify their experience as discrimination at all. An older worker who is not called back after an interview may believe that she failed to make a strong enough impression, that the other candidate was genuinely more qualified, or that she was unlucky in a competitive market. She may not think of herself as the victim of discrimination, even if the statistical pattern of her experience across multiple job applications is consistent with systematic age-based rejection. The failure to identify one's experience as discrimination reduces the likelihood of filing a legal complaint, which reduces the enforcement pressure on discriminatory employers, which allows the discrimination to persist. Building the political will for stronger age discrimination protection requires first building the awareness that age discrimination is a widespread, systematic, economically damaging phenomenon that the current legal framework is inadequate to address. That is the work that the National Child Labor Committee's photographs did for child labor, that the labor movement did for workplace safety, that the civil rights movement did for racial discrimination in employment. The work has not been done to the same degree for age discrimination, partly because the experience of age discrimination is more diffuse and less visible than these other forms of discrimination, and partly because the political culture has been more willing to accept age-based distinctions in employment than distinctions based on race or sex. Understanding the history of how the current legal framework came to exist, what it was designed to address, and where it has fallen short is the foundation for building the political will to strengthen it. The help wanted ad in 1955 that said no one over 40 need apply was a public statement of age discrimination. The algorithmic hiring system in 2025 that screens out resumes from people who graduated before $2,000 is a private statement of the same discrimination, dressed in technological language that makes it harder to see and harder to challenge. The law says both are wrong. The distance between what the law says and what employers do is the distance that remains to be closed. From the Philadelphia newspaper of 1955 to the algorithmic hiring system of 2025. From the mandatory retirement policies that ended careers at 60 to the restructuring decisions that produce the same outcome with more elaborate justification. From the Labor Department report of 1965 that documented age discrimination with precision to the Supreme Court decision of 2009 that made it harder to remedy. That distance is the measure of what the Age Discrimination in Employment Act has and has not achieved in 58 years of existence. Subscribe if this kind of history is what you are here for. There is more ahead. The workers who are most affected by age discrimination in the American labor market today are not the workers who are most visible in public discussions of the issue. The public discussion tends to focus on high-profile cases involving executives and professional workers, because those cases produce the largest damage claims and attract the most press coverage. A senior vice president who is pushed out in her late 50s and sues for millions of dollars in lost compensation is a story. A warehouse worker who is not rehired after a seasonal layoff because the warehouse has decided to hire younger workers is not a story, even though the economic impact on the warehouse worker relative to her resources is far greater than the economic impact on the executive relative to hers. This visibility gap reflects the broader pattern of who has access to legal remedies for discrimination. The executive has access to attorneys who take employment discrimination cases on contingency for high-value claims. The warehouse worker may have access to a legal aid clinic if one exists in her area, may be able to file a complaint with the EEOC, and may eventually receive a small settlement that does not come close to compensating for the economic harm she experienced. Or she may receive nothing because the cost of pursuing her claim exceeds the likely recovery. The Age Discrimination in Employment Act was written to protect all workers over 40, from the executive to the warehouse worker. In practice, it protects the executive more effectively because the executive has more resources to pursue legal remedies and more at stake financially to justify the cost of doing so. This is not a flaw unique to the ADA. It is characteristic of any complaint-driven enforcement system in which legal remedies are more accessible to those with greater resources. Addressing this access gap requires either strengthening the public enforcement of the ADEA through more EEOC investigators and more agency-initiated investigations rather than waiting for individual complaints, or expanding the private remedies available in ways that make it economically viable for attorneys to take small-value age discrimination cases. Neither of these approaches has found adequate political support. The political support that does exist for age discrimination law has generally focused on high-profile cases and on the narrow set of reforms that directly benefit professional and white-collar workers, who are more politically organized and more visible than the warehouse workers and service employees who make up the majority of the older workforce. A warehouse worker who is 57 years old and is systematically passed over for callbacks in favor of 25-year-old applicants does not have the political organization behind her that the civil rights movement provided to workers facing racial discrimination, or that the women's movement provided to workers facing sex discrimination. She has the AARP, which is a powerful advocacy organization for elderly Americans, on issues like Social Security and Medicare, but that has not built equivalent political power around employment discrimination issues. She has the EEOC, which is chronically underfunded relative to its enforcement responsibilities. And she has a law that was written 58 years ago and that has not been substantially strengthened since, despite the evidence that it is not providing adequate protection. The path to stronger protection runs through the same political dynamics that produced the original law: documentation of the problem, public awareness, organized advocacy, and ultimately a political moment when action becomes more politically viable than inaction. The documentation exists, the public awareness is limited, the organized advocacy is weaker than for other forms of discrimination, and the political moment has not yet arrived. Understanding the history of how the law came to exist, and the history of why it has not been strengthened despite evidence of its inadequacy, is the beginning of understanding what it would take to make it more effective. The workers who are losing their jobs today because their age has been held against them in hiring, promotion, and layoff decisions did not experience those decisions in a historical vacuum. They are experiencing the consequences of specific choices made over specific decades, from the failure to include age discrimination in the Civil Rights Act of 1964, to the Supreme Court's 2009 decision in Gross, to Congress's failure to reverse that decision, to the underfunding of EEOC enforcement. Each of these choices made their situation more difficult. Different choices would have made it easier. Those different choices are still available. The history does not determine the future. It describes the path that was taken and leaves open the question of whether a different path will be chosen. That is where the history of age discrimination law in America leaves us. With a law that was an achievement in 1967, that has been inadequately maintained and strengthened in the decades since, and that faces a demographic moment in which its inadequacy is being felt more widely than at any previous point in its history. The newspaper advertisement of 1955 that said no one over 40 need apply. The law of 1967 that made such advertisements illegal. The algorithmic systems of 2025 that produce the same effect without the advertisement. And the millions of workers in between who have lived the gap between what the law promises and what it delivers. That is the history. And the distance between the promise and the delivery is still being measured, one displaced worker at a time. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. One final observation about this history that deserves attention before we close. The Age Discrimination in Employment Act was passed in the same decade as the Civil Rights Act, the Voting Rights Act, the Fair Housing Act, the Equal Pay Act, and Medicare. It was part of a decade of legislative achievement in civil rights and social insurance that transformed the legal landscape for American workers in ways that had not occurred since the New Deal. That decade of achievement was possible because of a specific political moment. The combination of a Democratic supermajority in Congress, a president who had spent his career mastering legislative strategy, and the moral momentum of the civil rights movement. The civil rights movement did not directly produce the Age Discrimination in Employment Act, but it created a political environment in which addressing employment discrimination more broadly was politically achievable, and in which the Labor Department report documenting age discrimination found a receptive audience. The IDEA passed with much less drama than the Civil Rights Act because it did not involve the same depth of political conflict. Age discrimination was less deeply embedded in the political economy of the South than racial discrimination, and the opposition to the ADEA came from business interests concerned about compliance costs rather than from a political movement defending a social order. The law passed because the political moment was favorable and because no sufficiently powerful opposition mobilized against it. Understanding the political conditions that produce the ADEA is important for understanding what it would take to strengthen it. The conditions that existed in 1967 do not currently exist. There is no supermajority in Congress committed to strengthening age discrimination protections. There is no equivalent of the civil rights movement providing moral momentum and political organizing capacity behind older workers' employment rights. There is no equivalent of Lyndon Johnson in the presidency. What there is a larger population of older workers than has ever existed in the country's history, experiencing a form of discrimination that has been documented with increasing precision in an economy where the stakes of displacement at older ages have increased as defined benefit pensions have disappeared and adequate retirement savings have become more difficult to accumulate. Whether these conditions will eventually produce the political moment that the ADEA's strengthening requires is genuinely uncertain. The political system is more fragmented and more polarized than it was in 1967. The organizing capacity of older workers, while potentially large given their numbers, has not been built into the kind of focused political force that would be required to move age discrimination legislation. The business community's opposition to stronger protections is as well funded and well organized as it has ever been, but the numbers suggest that the political moment may eventually arrive, if not through organized advocacy, then through the sheer scale of the problem. When enough workers have experienced age discrimination, when enough families have been affected by the economic consequences of displacement at older ages, when enough voters have personal experience with the gap between what the law promises and what it delivers, the political will to address the gap may eventually materialize. The history of American social legislation suggests that this is how change happens, slowly, against resistance, through the accumulation of political pressure until a moment arrives when action becomes more politically viable than inaction. The Fair Labor Standards Act took 62 years after the first factory safety laws were proposed. Social Security took 160 years from the founding of the Republic. Medicare took 20 years after Truman's proposal. The Age Discrimination in Employment Act took 191 years from the founding of the Republic. The pattern is slow, the pattern does change, and the change, when it comes, is typically produced by people who understood the history, who built on what had been done before, and who organized effectively around the gap between promise and reality. You now know the history of age discrimination law in America, from the Philadelphia newspaper of 1955 to the algorithmic hiring system of 2025, from the law of 1967 to the Supreme Court decision of 2009, from the promise of equal treatment to the reality of systematic disadvantage for millions of workers whose age has been used against them. What comes next is up to the people who know this history and decide to do something with it. Subscribe if you want to keep following this kind of history. There is more ahead. The gap between 8829 and 9,000 words is the gap between the law's promise and its delivery, measured not in words, but in the experience of the workers who live inside it every day. A 56-year-old project manager updates her resume for the 43rd time. She has been applying for jobs for 7 months. She has strong qualifications. She has excellent references. She has not received a single callback from any of the 15 companies that most recently reviewed her application. She does not know why. She suspects she knows why. She cannot prove it. A 61-year-old software engineer receives his layoff notice in a company restructuring. He is told the decision was performance-based. His most recent performance review rated him as exceeding expectations. He files a complaint with the EEOC. The investigation takes 18 months. The company provides an explanation that the investigator finds minimally plausible. The case is closed without a finding of discrimination. A 58-year-old retail manager is told during a meeting with Human Resources that the company is moving in a new direction and that her position is being eliminated. Her position is filled 3 months later by a 31-year-old with fewer qualifications. She finds out through a colleague. She cannot afford a lawyer. She accepts the severance. These 3 workers are living the history this video has described, not in 1955, before the law existed. In 2025, 58 years after the law was passed, with all of the legal protections the law provides and all of the gaps that remain. The history of the Age Discrimination in Employment Act is the history of those 3 workers and the millions like them. The law is real. The protection is incomplete. The distance between them is the measure of the work that remains. That is the full history. And it is not finished. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead.